morning, everyone. Thank you very much for joining us. Welcome to our webinar considering the protection of cultural heritage by the ICC. I'm Kirsty Sutherland. I'm a barrister at 9 Bedford Row and your cruise director for this evening. I'm also a visiting fellow with Oxford's Institute for Ethics, Law and Armed Conflict, three concepts that occasionally fail to intersect, and also co-counsel for Al Hassan before the ICC. For obvious reasons, this evening I will remain completely neutral and will not be drawn into giving any view on current cases. Our panelists this evening are Dr. Umar Bar, Assistant Professor of Political Science at Morehouse College and soon to be joining the faculty at Cornell. His book, States of Justice, The Politics of the International Criminal Court, posits a dynamic process through which states, especially those presumed to be weaker in the international system, use the ICC as leverage in their domestic conflicts and to empower themselves in the pursuit of their political and security interests. Umar is primed to kick off our discussion by providing great insight regarding the politics of international justice, the global governance of atrocity crimes, and cultural heritage in conflict. We're also joined by Matt Cross, Appeals Counsel with the ICC's Office of the Prosecutor. He has plenty of experience across the ICC, ICTY, STL, and the ICTR, and also sits on the editorial committee of the Journal of International Criminal Justice, which means I'll probably be sucking up to him later. Matt is kindly going to talk us through the OTP's recently issued draft policy and its motivations and goals. And finally, 9 Bedford Row's own Josh Kern, a barrister also with plenty of ICL experience under his belt, will provide a response to the issues identified in and by the draft policy, looking both at its implications for the ICC's investigations and cases and what it might mean for the wider world. Before we start, a small housekeeping note. The discussion is being recorded this evening. In view of our lineup and the sensitivity of ongoing proceedings, please note that we're all speaking exclusively in our personal capacities. We will keep time for audience questions at the end, but please send questions my way in the chat box as we go, and I will happily pose them to the panel. So, the preamble to the Rome Statute starts off with the statement that the states parties to this statute are conscious that all peoples are united by common bonds, their cultures pieced together in a shared heritage, and concerned that this delicate mosaic may be shattered at any time. At the outset, I would note that this seems to claim both some sort of common conception of humanity and a static, singular, objectively existing heritage. I would also observe that the ICC is tasked with judging individual criminal liability, and our judges are lawyers, they're not anthropologists. And is the ICC properly equipped to perform this very, very delicate task? I expect our speakers will go into all of these things in great detail. The Rome Statute's war crimes provision, Article 8, criminalizes intentionally directing attacks against buildings dedicated to religion, education, art, science, or charitable purposes, historic monuments, hospitals, and places where the sick and wounded are collected, provided that they are not military objectives. Fine, so what has the ICC been doing with that? Well, in 2016, in the Al-Mahdi case, this was the first prosecution and conviction on a guilty plea for the war crime of destruction of cultural heritage at the ICC. In 2017, the ICC prosecutor and the Director General of UNESCO signed a letter of intent to strengthen ICC and UNESCO cooperation on the protection of cultural heritage. Notably, the press release claims that attacks against culture have regrettably become more frequent, which I think raises a number of questions that I anticipate will be addressed tonight, including about the history books the institution might wish to read. 2018 saw the issuance of arrest warrants for Al Hassan and Alfred Yakatom on charges including the destruction of buildings dedicated to religion, and of course those proceedings are currently ongoing. As mentioned, the ICC's Office of the Prosecutor has recently published its draft policy on cultural heritage. I'm going to pop the link in the chat box in a moment for those who'd like to have it to hand. And in a plot twist, just a few days after the OTP published its draft policy, the appeals chamber delivered its judgment in Ntaganda. While rejecting the prosecutor's appeal, 3 out of 5 judges did suggest that, unlike the trial chamber, they perhaps accepted the prosecution argument that attack for the purposes of Article 8.2e, 4e, 4 and 8.2b9 does not require a nexus to the hostilities. Anyway, that's enough from me. You want to hear from our panelists. So Omar, please talk us through your scholarship and your thinking on the economy of cultural heritage and governance.
Thank you, Christy, and hello, everyone. Thanks for the invitation to share this space. My brief remarks will be focused on cultural heritage and the economies of their governance and how it ties to the prosecution of atrocity crimes. And I framed these remarks around a couple of tensions and issues that are worth considering further, and some questions that might be worth also probing deeper. One of the first questions that I wanted to raise is where do crimes of destruction of cultural heritage fit in the broader context of atrocity crimes? Also in the broader context of international conflict and international criminal justice. What is gained or lost in the prioritization of such crimes? On the outset, I'll also mention that I am not a lawyer. I am a political scientist by training, and I study the politics of international criminal justice. So bear with me for not going into the technical details of the legal scholarship here. I focus more on the political aspects of the law and what the court does. As you all know, the Al-Mahdi case was what is oftentimes referred to as a watershed moment, even though it does raise a lot of complex questions and intentions, one of them being in whose interest are the focus of the prosecution for crimes of the destruction of cultural heritage, and whose priorities are those. The prioritization of the crimes against cultural heritage in the Al-Mahdi case in Mali, I argue, is the result of a couple of things. One of them being expediency, especially from the office of the prosecutor. To the point that, as Professor Shabazz has written, Al-Mahdi may even have been convicted of a crime that he did not commit, again, in the name of expediency. The other reasoning behind the prioritization of these crimes against cultural heritage in the Al-Mahdi case, I think, has to do with the convergence of interest between the OTP, the Malian state, and the international community. And in this case, UNESCO stands in for the international community. What is left outside of these questions is, what about the local communities? What about the residents of Timbuktu? What about the Malians themselves? I conducted interviews in December 2016 in Mali. I went to Bamako, Djenné, and Timbuktu, and I talked to the local populations. Something that came out of these conversations over and over again from the local communities is, what about the more serious crimes? By which they meant, why did the ICC focus only in the Al-Mahdi case on the crimes against cultural heritage and ignore all other crimes that were committed during the jihadist takeover of Mali? Another issue that the population that they raised is the idea that Al-Mahdi himself is actually a little fish. And this was at the time when the OTP was publishing their strategic plan, the 2012-2015, where they tried to focus more now on pursuing lower level commanders and mounting up from there. Another issue that came out of these interviews with the Malians was the idea that the international community views the Malian conflict through the lens of good rebels versus bad jihadists. The rebels can be negotiated with, the rebels can be brought to the table for negotiation, sign treaties, whereas the jihadists must be prosecuted. Interestingly, in the Al-Hassan case, we see some kind of readjustment from the part of the OTP, especially when it comes to the broader list of the indictment of the crimes that Al-Hassan has been pursued for, compared to Al-Mahdi, for instance. And a final point on this one is the idea also that the International Criminal Court is an international organization. It is an IO. And as such, it is concerned with its own image, its own legitimacy, and its own legacy. So the decisions that it takes and the priorities that it pursues, similar to UNESCO and the international community, quote unquote, may not always align with the priorities or the concerns of the local constituencies that the ICC purports to serve, in this case, the victims. But then again, who are the victims in these kind of crimes? Is it the local communities to whom this heritage belongs? Is it the states where these crimes were committed? Is it the international community? Is it UNESCO? Or is it humanity at large that is being victimized when these sites, these cultural sites are attacked? In any case, these different constituencies, I think, do have different relations, understandings to these cultural artifacts, and these sites do hold different meanings to different actors. And as such, who gets to decide what is sacred and of outstanding value to humanity as a heritage? Who has the legitimacy to challenge such decisions? And what are the avenues to contest such decisions? Under which circumstances do different approaches of administration of the economy of cultural heritage is deemed legitimate or acceptable or reprehensible? One example being Saudi Arabia, for instance, having destroyed a lot of cultural and religious sites through religious decree, or because of real estate developments, other cases of the US native lands that are being destroyed in the name of developing pipelines, for instance. So again, who has the legitimacy of contesting and ascribing the value of these sites, or deciding what to prosecute and what not to prosecute? Finally, and I will stop there, beyond the headlines, I think, and beyond the shock value of destruction of these cultural heritage sites, it would be helpful to try to think of this destruction of cultural heritage as a crime. Yes, probably it is a crime. I will defer to the lawyers on this. But also destruction of cultural heritage as an act of governing. So when Ansar al-Din was destroying these sites in Timbuktu, Timbuktu was already under the effective control of Ansar al-Din. So, and we have a lot of scholarship on rebel governance in political science that does teach us this, that rebels who hold a territory, that territory is not just lawless. They do establish procedures of governing and controlling the populations and the territory under their control. So these are not just simply criminal acts. They are not just signals sent to the international community. These destruction of sites can be the result of very thoughtful process of restructuring political life in the territory under jihadist control. For instance, the destruction in Timbuktu was carried out over many months. So this is not just something that was done in the spur of the moment. This was a deliberate process that is linked to the idea of administering the territory, which Michel Foucault has referred to as a gouvernement. that he defined as attempt to control the possible field of action of others. And that does include, quote, the government of souls and of communities. And I'll stop there. Thank you.
Thanks so much, Umar. I'd just like to invite Josh and Matt to ask any questions they might have.
I don't have a question just yet, Kirsty, but I will come back.
Matt?
I think I'll be the same, other than saying I very much appreciated Umar's comments. Thank you.
Well, quick question for Umar, though I suspect we're going to go into that in more detail later. Is the ICC's reliance on UNESCO, do you see the ICC's reliance on UNESCO, well, A, as existing, or is it acting independently, or do you see that relationship as potentially problematic?
I think there's been a convergence of interest between the ICC and UNESCO, especially when it comes to the Mali situation. The ICC got a hold of Al-Mahdi at a time where it needed good publicity, where the OTP was struggling with carrying out effectively the cases it had, and then they needed a quick conviction and a trial that would not take many years. The UNESCO itself also is an institution that is oftentimes politicized to the extent that there's a legitimacy question to the UNESCO. It is also an institution which have a very problematic view of what constitutes cultural heritage. The registry, the UNESCO's definition of what constitutes cultural heritage, UNESCO's history itself has been Eurocentric. The process of registering these sites is a very politicized process. States do use this registration for cultural heritage for tourism purposes, for instance. And therefore, for the Malian situation, I think it was a situation in which both the ICC and the UNESCO figured out that this is quite an easy thing to carry out and to do and to prosecute, and then to raise a fund, and then to rebuild some kind of a positive image for both institutions.
And sorry to come back on this, but when you say a legitimacy issue for UNESCO, could you elaborate to where do you think the legitimacy issue stems?
So one example I could give quickly was in the 80s, UNESCO was led by Ahmed Mokhtar Mbow from the Global South, from Senegal, who tried to bring in a lot of changes to the organization itself, but beyond that, to the international order. And this is the time when the UK and the United States left UNESCO, actually, as a response to the changes that the Global South was trying to bring into the international order through UNESCO. Well, the US would also leave UNESCO again and again. So this has been an occurrence that has happened a lot of times. So UNESCO is not without its own issues. It's not without its own problems. And there's been instances where some sites has been registered, Tibet, for instance, and there's been controversial sites that has been brought up by some states, which UNESCO has taken up. There's also criticism, especially from Meskel, for instance, who has shown that in many instances, the scientists, their reports have been sidelined in the name of expediency for political purposes in registration of these cultural sites. So that's what I meant by UNESCO itself does have some legitimacy issues around a lot of corners. and therefore the attacks of these sites in Timbuktu had been an opportunity for UNESCO to come back to the global stage with the support of the international community, just like the ICC was able to, the OTP especially was able to capitalize on the Al-Mahdi case and get a quick conviction.
Kirsty, could I just follow up with a quick question for Umar?
Yeah, keep it brief because we're eating into Matt's time.
Sorry, just a very quick one, Umar. Just whilst you were talking about UNESCO, you said UNESCO stands in for the international community in this context, and the ICC too. And maybe Matt can touch upon this as well. The ICC too is often claims to stand in for the international community. Do you see a parallelism there, and what aspects of what you've just spoken about with respect to UNESCO do you think could be said about the ICC?
Yes, that's a good point. There is a parallel, of course. Both institutions claim to speak for humanity. So when UNESCO raises questions or issues or warnings that some sites may be in danger of being destroyed, or when the ICC comes out and says, for instance, some crimes against humanity are being perpetrated, so that humanity is the same one that both UNESCO and the ICC try to speak in favor of. Now, the difference there is that, as you know, the ICC is a treaty-based court to which a lot of states are not members of. So then again, the ICC cannot in de facto speak for all states, even though it does pretend to speak for humanity by prosecuting crimes against humanity.
Great. Well, Matt, over to you. The draft policy, what motivated it? Why was it necessary? Will it change practice at the ICC? How do you hope it will change practice? Let's go. Thank you.
Thank you, Kirsty, and thank you for the invitation to come and speak this evening. Before I start, I should just make the usual caveat to say that I'm speaking here in my personal capacity only, and I'm not here as a representative of the ICC Office of the Prosecutor as such. But I am privileged to be able to discuss the Office's draft policy on cultural heritage this evening. I know that I'm going to discuss the draft policy. We are very grateful to have had a consultation and feedback process on the draft policy. And I know the Office is currently studying those comments, and probably we can expect the final version of that policy to be published sometime reasonably soon. But for this evening, I'm afraid I'll keep my comments to what's in the draft policy and not what's in any document which is yet to come. I'm very grateful in particular to Kirsty for her opening remarks and to Umar for his presentation, because I think they've already taken us straight to some of the key questions we're going to be asking this evening. They have asked whether the ICC Office of the Prosecutor should be approaching the question of cultural heritage with suitable humility and modesty. They've asked questions about legitimacy. They've asked questions about expertise. And I think these are all absolutely the right questions to be asking. And in my comments this evening, I'm going to try and address two things. One, I will try and talk about why policies are useful, particularly for the kind of vexed questions which have been already put into play in our discussion so far. And secondly, I'm then going to talk very briefly and in quite a personal way about 3 or 4 of the points in the draft policy, which I think are particularly to be welcomed and are worth bearing in mind as we go forward. And then I suspect Josh in his remarks may give us the benefit of some bracing criticism, which might kind of counteract my approach. I see him shaking his head, so I might be wrong about that, in which case that's even better. We have the undoubted challenge as international prosecutors that we are going to be dealing with issues of culture, and we are going to be dealing with issues of cultural heritage, because that is the context in which international crimes are committed. And those are always going to be difficult questions and difficult issues. We also have the challenge as international prosecutors that there are aspects of the work which hinge on prosecutorial discretion, where the prosecutor has to make choices about why one course of action rather than another course of action is pursued. And it's in that context where those two key challenges come together that the practice of a prosecutor's office like the ICC prosecutor publishing public policy documents, I would suggest, is actually very useful and is a way for a court, for a prosecutor's office, to approach these difficult questions with a certain measure of humility. And that's because essentially what we're doing is we're putting out into the public domain an initial view of what the office's response to a certain set of challenges might be. And that's a moment to invite conversation more broadly with the community of stakeholders which the prosecutor represents. And it's that transparency, it's that opportunity to identify what are the key questions, what are the things that perhaps the prosecutor and her staff haven't considered well enough, where is the expertise, what are the things we should be worried about. It's by starting that ball rolling, having a conversation, that we are ultimately going to do a better job of dealing with these difficult issues. And as we all know, we're all, or rather many of us are counsel here. We know that trials are not the place for an academic discussion. We also know that a very general academic discussion may not necessarily deal with the practical problems that we have as practitioners. So we're looking for some kind of space in the middle. And as we've seen with the prosecutor's previous policies on crimes affecting children, crimes affecting sexual and gender-based violence, we have a whole raft of substantive legal questions, questions about process, questions about expertise, all of which come together. And so by bringing out these thematic policies, really the international prosecutors' offices can try and make available an opportunity to discuss the key questions. Some might say the publication of a policy is the end point in the process. I'd rather suggest it's a form of punctuation. Policies can, of course, be revised, they can be changed. They are a means of the prosecutor coming forward in good faith and saying, this is why I think this is an important area to discuss. These are the principles which I'm bringing forward. This is the approach I'm considering taking, and we can go from there. It's a two-way discussion also. Some occasions you might think policy is testing what the views of the international community might be on a particular issue. On other occasions, it might be crystallizing practice which has developed over time. As we all know, international trials can take a very long time, and all of us who work in prosecutors' offices will eventually move on and do something else. And there is a danger that institutional memory might be lost. Again, by laying out a policy, there is room for a more formal process of reflection and deliberation and consultation by which we can try and explain why certain historical decisions might have been made, how the office might wish to act in the future. And of course, at such times as we have a change in leadership, as at the ICC we are shortly going to be having, that's also an opportunity for one generation, if you like, to talk to the next generation. It doesn't necessarily mean that there will be a complete continuity. Obviously, the new prosecutor is always going to have a free hand to act as they think appropriate for the time of their mandate. But it creates a space in which we can ensure appropriate consistency for as long as we're getting things right. And equally, if we're getting things wrong, it's a moment by which we can take stock and address the problems which might be identified. So I would argue that precisely because of all of the difficulties that might arise from an issue such as the protection of cultural heritage, I'd say that's exactly the time when it might be appropriate to have a public policy, to have a public discussion, and to endeavour to set out how the office will respond to that in the cases which are coming up. And again, by doing so, it also helps to dispel the impression that the office is perhaps acting in an entirely pragmatic or expedient manner. It helps to show the nature of some of the concerns that may be underlying the office's practice. In other words, to put a long story short, I would say policy documents help with the legitimacy of prosecutorial decision-making. And it's in that context that I would suggest we should be considering the new draft policy on cultural heritage. Now, just to take it's a rich document, there are many things in it, but perhaps I might highlight 4 things in the draft policy which I think are particularly worth bearing in mind for the future practice of international criminal courts such as the ICC. First of all, the draft policy does not seek to replace or to supplant the wider scheme of protection for cultural heritage in public international law and elsewhere. It has a much more modest aim, which is really focused on the mandate of the ICC prosecutor. And in that context, the idea is simply to recognize the existing implications of those general principles relating to the protection of cultural property and cultural heritage when international crimes are carried out. In other words, when there already is proof of a widespread or systematic attack against the civilian population, or when there is an armed conflict, and so on. In other words, it's not about international criminal lawyers trying to expand the job they were commissioned to do. It's not about international criminal lawyers looking at issues which they do not have to look at anyway. It's simply about trying to do that job better. Many of the issues which are indeed vexed and difficult and require consideration and appropriate expertise are existing in the cases with which the ICC is called to deal with anyway. And we should be honest and open about those challenges that we see before us and how we are planning on tackling them. Secondly, I would note that the draft policy addresses cultural heritage in a broad sense and not merely cultural property. As we know, the notion of cultural property under various labels may have particular legal significance under IHL and thus particularly under the war crimes provisions of the Rome Statute. And of course, in its practice already, in cases such as Al Mahdi, the office has already marked its commitment to prosecuting those kinds of crimes where they may arise. But the draft policy also takes a broader view because it recognizes that crimes affecting cultural property are just one of the ways in which crimes may affect or be informed by notions of cultural heritage, which is a much broader concept. And this is important, I would suggest, because it helps to place the spotlight where it belongs, which is on the real significance and meaning of international crimes for victims and affected communities. The cultural context of international crimes is not just significant for the effect that those crimes may have. It's also significant potentially for the way in which those crimes may be carried out. It's significant for what they may be understood to mean, or for the particular kinds of conduct which might be perpetrated. So by exploring notions of culture and cultural heritage, as prosecutors, it helps to get past our own backgrounds and experiences and to try and understand the real significance of the events in question for the people who lived through them. And if we're worried about an ICC which might be seen as too remote and too distant from the places and the people who are affected by crime, deep and genuine engagement with issues of culture and heritage, in my view, may be an important part of addressing this. Third, when the draft policy talks about cultural heritage, it's not just talking about objects or practices which are recognized in some way by the international community as being special. Of course, recognition by the international community might be of great relevance, perhaps especially when we're considering issues of gravity, But it's important to recognize that cultural heritage is not just those things which are valued by people far away. And if we think seriously about cultural heritage, that means, as I think Umar implied in his presentation, that means thinking seriously both about the significance of the events in question at a local level, as well as the significance of those events at a global level. And it's really only if we can do these things together that we might adequately describe the harm that we suspect has taken place, and indeed hopefully prove that in court beyond reasonable doubt. Fourth, and finally, I would say the draft policy is valuable because it draws the attention of the international community to some very particular harms. Just one example of this is the trade in conflict antiquities, which may be a form by which external actors act parasitically on armed conflicts for their own personal enrichment. And in so doing, they have drastic and potentially permanent consequences for the affected communities in a particular place. And with the right fact pattern and the right evidence, prosecuting a case of this kind, for example, might be consistent with the ICC's existing track record in pursuing cases which represent traditionally under-prosecuted conduct, clarify the law, and seek to deter the further commission of crimes. And that's very much the approach that the office has taken so far in pursuing convictions related to sexual violence, crimes against children, and so on. I think probably with those brief remarks, I'll stop at this point in the interest of time, but I'm very happy to take any questions as they come up or as we go along. Thank you very much.
Sorry, struggling to find my unmute button. Thanks so much, Matt. I should offer the floor to Josh and Umar to ask a question, but I'm going to jump in. You've ended by noting the, taking a policy towards SGBV prosecution, etc. Now, is there a danger by focusing on specific areas of categories of crime that you neglect other crimes? If the court is out looking for destruction of cultural heritage, which, forgive me, some might argue is a sort of slightly easier thing to prosecute than very tricky situations of rape, which is of course hidden and difficult to elicit evidence about. So yes, is there a danger?
Thank you, Kirsty. I think, obviously, I'm not going to discuss any particular case today, but I think the practice of the court shows that, by and large, when looking at any particular case, the prosecutor is always going to pursue all of those charges which she thinks are grounded on the evidence that she has in her possession. Obviously, as a prosecutor, we can only ever pursue cases according to the evidence that we have, and that entails decision-making, that entails a measure of prosecutorial discretion, but always, obviously, our job is to follow the evidence. And I think, for example, in the ICC case selection policy, it says in so many words that the aim of the office is to represent as much as possible the crime which we believe to have occurred in the situation. And that's always going to be the aim. I think when we talk about things like the prioritization of pursuing crimes of alleged sexual violence, or crimes against children, or crimes affecting cultural property, what the ICC is perhaps trying to do is to highlight the fact that it is conscious of these crimes and that it will pursue them when it finds that they are established on the evidence, no matter what. It's not so much about saying we will give these crimes extra priority. It's rather about saying we will not underestimate or undervalue these crimes when we find evidence. So, for example, you gave the illustration of rape as a notoriously hard crime to investigate and prosecute, which is perhaps why the prosecutor's very first thematic policy was looking at sexual and gender-based violence. So when we're talking about new policies, it's not a zero-sum approach whereby to pursue one, we have to let go of another one. It's rather about developing our thinking as prosecutors over all the crimes within our jurisdiction, which will then prosecute where cases so demand that.
Yeah, I would observe that there are sort of some biases, I think, in emerging in sort of international criminal law that I think you're right. The policies are seeking to address. One of the blind spots remaining being crimes against children, which I know is the subject of much scholarship at the moment. With regard to Ntaganda, if you've got a sort of looser, weakened nexus requirement, is there a risk that wading into the situation would constitute interfering with potentially local or community decision makings as to what constitutes culture? And you mentioned in your presentation the conception of cultural heritage and cultural expertise, and I'd be really interested to hear who it is and how and what methodologies you would demand. Who gets to tell you what is the cultural heritage and how can that be scrutinized? I'm very interested to hear your thoughts.
I think probably there are a few questions there. Just to deal with Ntaganda first. Of course, we have two things arising from Ntaganda. One is we have the recent appeal judgment from, 6 weeks ago, which is looking at the prosecutor's appeal, as you said, on Articles 82E4 and 82B9. And I think it's probably best just to say that at the moment we are of course studying that appeal judgment and thinking about what that means for our practice. But as you'll recall, the number of separate opinions from the appeals chamber were quite considerable, and they all take a slightly different view of the questions that we raised in our appeal. And so obviously there is room for further litigation or further judicial discussion on that point. And the office will remain, I suspect, interested in that issue. In terms of watering down the standards and the nexus, it's interesting because, of course, the Ntaganda, the same case, Ntaganda, in a previous appeals decision at the interlocutory level, in fact, underlines that the nexus requirement for war crimes should be, and I quote, rigorously applied. And I think that would be very much our view as well. It's a factual matter. It's a well-established test which is satisfied by evidence. And of course, in the context of war crimes prosecutions, we will always be looking to only prosecute conduct which is genuinely a war crime, which is to say it has a nexus to an armed conflict. And if it doesn't have a nexus, then we wouldn't be trying to prosecute it, in our view. And I think the existing legal framework of the Article 5 crimes remains absolutely crucial. As I said, I don't think the draft policy is in any way suggesting that the ICC has any business in dealing with issues of cultural heritage which are not part of an Article 5 crime under the Rome Statute. The question is, for us, when we do have such crimes, or we believe we have such crimes, then how to engage with the issues of cultural heritage as they arise, precisely because we don't want to undervalue them or fail to spot criminality or fail to understand really what the significance is of particular conduct when we discover it in our investigations. And that brings me to your last, I have to say, excellent question, which is, well, how will we know? And the only thing I think I can say helpfully about that is we know by doing thorough investigations, talking to the right experts if we can find them, talking to witnesses, trying to find out what went on, and then putting our best case forward, and it's tested before the court in the usual way. And inevitably, there will be room for discussion sometimes about the view that is taken, because these are difficult issues, and of course there are going to be views going in both directions. But fundamentally, we're prosecutors. This is a court. At the end of the day, we've got to prove it. And we either prove it or we don't. And if we don't, then that's the way it goes.
Thank you for that very clear and cogent explanation. Josh, Umar, any questions immediately arising for Matt, or
just a quick one?
You do you do get your whole presentation of right of response. So
that is true, but it's just, Matt, do you know if the comments that you've received in the office on the draft policy will be published before the amended policy itself?
I don't know exactly what the process will be in that respect. And I think probably I shouldn't comment on that further, just because I'm not here today with my official hat on. Sorry not to be more helpful.
Fair enough.
Umar, anything?
Yes, a quick question, Matt, and thanks for your very excellent comments. Prosecutor Bensouda has said repeatedly that she is guided by the law, not politics, which I think is a problematic statement because the law is politics, but that's a discussion for another day. Do you think that such a position, such a posture would be an impediment for the OTP to pay enough attention to culture and cultural context? This idea that we are only guided by law would blind you to pursuing or trying to understand things that may be outside the law, such as the cultural context, for instance.
Thank you for a very thoughtful question. I think I should say, in the way I answer, I'm not going to even try to speak for Prosecutor Bensouda. So I'll leave her words as they are, and I'm just going to speak for myself. But in speaking for myself, I think as lawyers, of course, and particularly as prosecutors, because our conduct as prosecutors has consequences on the rights of other people, we're always going to act ourselves according to the law. And therefore, when we take decisions, we are going to take decisions according to the law. Sometimes the law gives a choice to the prosecutor. You have discretion to do this thing or that thing. And then obviously the discretion will be exercised along the lines which best serve the mandate of the prosecutor. I think your question also goes into a slightly different area, which is how might lawyers understand crimes which occur in a political or a cultural context? And of course, as a matter of evidence, we do our very best to understand the subtleties and the nuances of what is going on when a particular set of events happen in a particular place. But we don't do that in isolation. We do that through evidence, through expert witnesses, through what people tell us. So my answer would be to say, as lawyers, absolutely, we are guided by the law. But in trying to understand a situation, of course, we should listen to experts and witnesses and all the evidence which is available to try and really understand what is going on. And there's, I hope, a kind of reasonably clear division between those two issues. Does that answer your question? I think it's probably the best I can do for now.
Yes, it does. Thank you.
Thank you.
Well, Josh, over to you. We are running a little bit late. I'm very, very keen to take questions from the audience. I will tick you off right now because there aren't any in the chat box. Please do send them along. But if you'll bear with us, we'll run over a little bit. And yeah, Josh.
Thanks, Kirsty. And thank you, Matt and Umar, so much for your comments and remarks. I hope I can just add something to the depth and the texture that you guys have already provided. And thank you also to everybody who's tuned in the audience. We're honored to be joined by all of you, including some giants of not only international criminal law, but also giants of this specific subfield of protection of cultural heritage. So thank you to all of you for joining us. As Kirsty said at the beginning, I've been asked to respond to some of the issues raised by the OTP's draft policy from both an internal angle, looking at the draft policy in terms of its potential ramifications on ongoing investigations and cases, and as well as from an external angle, and in terms of what the policy might signify for the wider world outside of the court, the 2/3 of humanity who don't live in states which are parties to the Rome Statute. So first, the internal angle as described, and my remarks here are grouped into 4 headings: transparency, narrative, UNESCO, which we've touched on a little bit already, and a few words on the principle of legality. First, transparency, just to echo what Matt said. The policy consultation, like all policy consultations undertaken by the office, can only reflect welcome transparency. And I know that Matt's speaking in a personal capacity, but I would say that his willingness to participate and engage with us in this way reflects that same spirit. So thank you for that too. Because it's, as Matt also suggested, it's precisely through engagements such as this that mutual trust between the court and its stakeholders can be fostered, and that's something that as officers of the court we should all endeavour to promote. There's a broader benefit too, I would say, because the discourse which is facilitated as a result creates opportunities for engagement, as Matt said, outside of the adversarial context of criminal litigation, which inevitably engages hardened positions resulting from criminal allegations, which necessarily polarize points of view, especially insofar as they relate to matters affecting cultural heritage. Narrative. We can perhaps all agree that the OTP, as an organ of an international court which prosecutes international crimes, should avoid adopting or cherry picking one party's narrative when it comes to matters affecting cultural heritage. Yet, on a webinar on prosecutorial discretion on the 9th of March, Rod Rastan suggested that the OTP has less qualms than one might expect with one-sided investigations if the cooperation is only received from one party to a conflict. And such an approach, it might be argued, risks resulting in an exercise of jurisdiction which may ultimately harm cultural heritage and cultural property, both tangible and intangible, through a failure to acknowledge and recognize competing claims or narratives, and risks furthering conflict, and directly or indirectly contributes to shattering of the delicate mosaic of common bonds that Kirsty referred to as stated in the preamble of the Rome Statute, and as well the fragmentation of international law, which is a subject I'll try and return to at the end when discussing the potential effects of the OTP's draft policy on third states and those outside the court. Just a note on that. I mean, it seems difficult to see how such an approach could be squared with the approach adopted in the draft policy, that the office will adopt a holistic approach to consideration of crimes against or affecting cultural heritage at all stages of its operation. And that's just one element on narrative that I think deserves attention. Relatedly, Kirsty asked Umar, how deep is the reliance on UNESCO, and what are the factors for and against this? And as Umar noted, in the Al Mahdi case, UNESCO stood in for the international community, and as he also noted, UNESCO is a political body, and by that I mean to say, and I apologize if this is stating the obvious, but UNESCO is not a judicial body like the ICC, which exercises judicial functions. It's a body in which a majority of states can discount the views of minority cultures if they come into conflict with the majority. And as Umar said in answer to Kirsty's question, such an imbalance could be reflected in both UNESCO's approach to designation of cultural property, as well as in its protection. There have been allegations, as Umar referred to, of politicization of UNESCO. The US has withdrawn from the agency on multiple occasions and has withheld funding for this stated reason. And we've also seen the argument play out, as Umar said, in Tibet, but also in Cyprus, between Thailand and Cambodia over Preah Vihear, and as well as between Israelis and Palestinians. The fundamentally different nature of UNESCO as a political body, as against the ICC as a judicial one, demands not only independence on the OTP's part from UNESCO's decision-making processes, but also an independent assessment of those decisions themselves. Turning to the principle of legality, regrettably, it seems that several of the suggested legal standards contained in the draft policy give rise to concerns with respect to the requirement of the Rome Statute to respect the principle of legality when it comes to the definition of crimes, and that they should be strictly construed and shall not be extended by analogy. We've discussed the interpretation of attacks under 82B8, 82B9 and 82E4 of the statute. And Kirsty asked Matt, what should the nexus, where should the nexus element be drawn in light of the appeals chamber's decision in Ntaganda? And by that nexus element, I understood the question to be referring to the degree of temporal or other connection between an attack on cultural property and the armed conflict itself, as required by Article 8. Now, looking at the appeals chamber's judgment, according to Judges Hofmansky and Morrison, an attack means combat action, or according to Judge Ibanez Carranza, the immediate aftermath thereof. The risk, it seems to me, of a broader interpretation is that it risks positing a definition of an attack that's indeterminate. Where should the line be drawn if such a broader interpretation is accepted? Would the scope of an attack extend to law enforcement action, for example? As Judge Moron noted in his monograph, The Humanization of International Law, the scope of the second protocol of 1999 to the 1954 Hague Convention would perhaps suggest not, at least in a NIAC. Article 22 of the second protocol states that the convention will apply to non-international armed conflicts occurring within the territory of one of the parties, though not to situations of internal disturbances and tensions. So if the scope of an attack were to extend to law enforcement operations, would effecting a lawful but forcible arrest of a criminal suspect seeking refuge in cultural property constitute an attack on that property? What's the threshold for the use of force in such a case? And if one accepts such a broader interpretation, how are government legal advisors to advise their ministries on where the line is to be drawn between, for example, a law enforcement operation and an attack? And what incentive might be provided to ordinary criminals, or even those engaging in political violence, to seek refuge in cultural property in order to invade law enforcement? I'm going to turn briefly to the external dimension of the draft policy and what the policy might signify to states outside the court. The court, of course, doesn't operate in a vacuum. It itself is part, as we've already acknowledged, of the delicate mosaic referred to in the preamble. And it doesn't seem to serve the interests of justice then for the court to adopt definitions of crimes which substantially deviate from rules of customary international law. And I wish to just discuss a brief illustration. And it derives from recent work undertaken by my colleagues, Stephen Kay, QC, Drea Becker and I, with respect to the conflict between Azerbaijan and Armenia over Nagorno-Karabakh, both non-states parties to the ICC. And in particular to the 7 districts of Azerbaijan that were occupied by Armenia between the conclusion of the international armed conflict between the two states in 1994 and their recapture in 2020. Drea and I visited the formerly occupied district of Fuzuli, close to the Iranian border, on the 21st of November 2020. It had been recaptured by Azerbaijani forces just over a month earlier. Fuzuli had a rich past and diverse cultural legacy. It's the site of Neolithic and Bronze Age residential areas, tombs, mosques, and caravanserai, which represented symbols of the cultural heritage of a land which is a cradle of civilization. Azerbaijan, for its part, characterized these monuments to be of national importance. In Fuzuli, Dreyer and I saw nothing less than an apocalyptic scene, with not a single civilian structure left undamaged or destroyed. We heard of and we saw with our own eyes widespread destruction of cultural heritage. We saw sites of destroyed mosques, desecrated cemeteries, not to mention hospitals and other civilian buildings. Yet when framing an analysis of what we'd seen and studied and the destruction caused during a 30-year occupation, we were confronted not only with the divergent jurisprudence of the ICC relating to attacks on cultural heritage, but also with a divergent approach of the ILC committee tasked with drafting a suppression convention for crimes against humanity, with the approach to the same subject matter that had been adopted by the ICTY. The ILC's draft convention currently proposes a definition of persecution as a crime against humanity that requires a nexus between the underlying act of persecution with other enumerated crimes against humanity. The ILC's proposed definition may serve to exclude from the definition of persecution precisely the type of destruction of cultural heritage that we saw in Fuzuli. On the other hand, arguably precisely the same type of destruction was prosecuted as persecution as a crime against humanity at the ICTY. So perhaps as a final suggestion, further consideration might be given to the interplay between the OTP's draft policy and issues relating to the fragmentation of international law itself. What interests are served through divergence between Rome Statute norms and norms of customary international law? Might non-states parties be encouraged to join the court if they observe an OTP that endeavours to harmonise where possible Rome Statute norms with norms of customary law by which non-states parties are already bound? Would such an approach foster and promote the court's universalist ambitions? And finally, is such an approach not only consistent with the Rome Statute's internal legal order, exemplified by Article 22, but also with the spirit of the statute itself, which seeks to safeguard the common bonds which unite us through the delicate mosaic? Thank you.
Well, thanks so much, Josh. I'll first invite Matt and Umar to ask any questions they might have for Josh. Really?
Go on then. Not so much a question as a comment. I think, Josh raises very cogently put concerns about where the law is after Ntaganda. And my comment would simply be to say, I think the interesting thing about Ntaganda is that it reflects in all the different opinions that were put forward exactly the intention that Josh asks for and with which I would agree, which is to make sure that the approach of the Rome Statute is consistent with the established framework of international law, which is actually in the chapeau of 8.2b and 8.2e. What was interesting, and I confess personally surprising about Ntaganda, was that the range of possible viewpoints on how to answer that question turns out to be rather broader than if you'd asked me beforehand, I would have said it would. And without going into the merits of it, I think the interesting question is, previously I'd have said, well, the appeals chamber will either rule one way or another way. And in fact, the way the judgment seems to read is that they're saying, hang on a second, even you prosecution are taking one position, but maybe there are other ways in which that might be interpreted. And so they've broadened the discussion. But I think we are all trying to achieve the same thing, which is exactly that. Yes, we are trying to achieve, as much consistency as possible between the Rome Statute and the established framework of international law, particularly for war crimes, where the statute requires that link. With crimes against humanity and persecution, obviously, it's a slightly different scenario because there clearly is some distinction between the definition of crimes against humanity in Article 7 of the Rome Statute and a definition of crimes against humanity under customary international law as prosecuted by the ICTY and the ICTR and everybody else. And that could be a whole webinar in itself. But just to say, I think we actually have, a common objective. It's just that this area of the law turns out to be surprisingly nuanced, even when you think, it's a straight two-way discussion. In fact, the discussion now seems to be a bit more of a broad one.
Do we have any questions from our very esteemed audience? I would be delighted to hear your questions, and thank you also to the people who are tweeting vigorously. It's exciting to see your commentary. Any interventions? Don't all shout at once. Okay, well, I will ask a couple of final questions. I don't want to be, this is going to sound like I'm dropping a bomb, but does culture trump religion? And who wants to answer that one? Or is there a danger that
religion is part of culture, is it not?
Bit of a cop out, Josh.
Hey, appreciate it.
Any thoughts?
Yeah, I think that would be a difficult question to answer, because that probably may presume that we can distinguish the two, one from the other, which oftentimes is not the case. I think the two are so intertwined together that it's hard to distinguish the two. But when it comes to ICL, I think there tends to be some bias against religion in favor of culture in instances where I think religion is oftentimes viewed with suspicion, especially within Western-based institutions such as the ICC, which technically is supposed to have a universal reach, but is built upon a Western-oriented ethos, which views with quite suspicion religion in favor of culture. But I'll just stop there.
Thanks, Umar. And also, I mean, we've all been touching on sort of the concerns or questions over the legitimacy concerns that bodies such as the ICC and UNESCO have. They are, of course, state-based bodies, treaty bodies, and that brings with it its own baggage. But who should the ICC, or if anybody, who should the ICC defer to when it comes to determining matters with cultural heritage? The questions over what cultural heritage is, where the expertise lies, who should it turn to?
If I may, I think this is it's also related to the last question relating to religion and culture. We didn't really touch upon the issue which has been raised in a number of the comments on the draft policy which have been published by their authors already, which is a number of the comments made have suggested that the draft policy could contain perhaps a more clear definition or a more developed definition of cultural heritage itself. And I think the question kind of demonstrates, both questions almost demonstrate the benefit that might be derived from a more clearly articulated definition, and then methodology, a clear methodology on the part of the office, which Kirsty you've referred to already, in terms of identifying and determining what constitutes cultural heritage worthy of protection in this context. That would be my suggestion.
Just if I might chip in, I would add that, of course, when we look at the policy, we're only looking at what the prosecutor's office understands to be the case. Ultimately, we're just a prosecutor's office. We can't do anything if we don't persuade an independent and impartial panel of judges based on the evidence that what we say is the case. And so when it comes to saying, well, who decides? We, I hope, have as wide an angle lens as possible when we look for the evidence. We get the best facts that we can get hold of. We make the best sense of the situation that we can do, but then we put it towards the judges. And to the extent of the question of fact, ultimately the judges decide based on the evidence that we put forward, based on the evidence that the defense puts forward, and based on any other evidence that the judges may obtain through the procedures of the court, and they will decide. And then when it comes to legal questions, the legal questions are no different in this context as they are in any other. The judges will decide the law. So although I agree that it's a vastly interesting and delicate and difficult set of issues which are raised in this context, in the fundamentals, I don't know whether it's any different from any other issue in a criminal case. It's just that these are hard issues and hard cases, but I think the process is the same.
Although in not every criminal case, Matt, are there such stakes at issue. And particularly when it comes to these issues as they relate to cultural heritage, because the cost of getting it wrong on your part is potentially, well, it goes without saying how high the stakes are. So do you see that this is somehow different in a way to an ordinary criminal case in that respect?
Could I also just jump in on a slightly related point, which is that while I agree with you that in theory we're leaving the judges to make purely legal determinations, the ICC I don't think can really be called a sort of normal judicial process. The proceedings are lengthy, they're public to varying degrees. Narratives are certainly put out into communities, even by virtue of those operating on the ground who may not be the OTP, but maybe reliance on CSOs, etc. That narratives are out there, and that does impact how communities respond to the ICC. Understand the it impacts the local understanding of events and potentially contorts it, some might argue. And again, it's states who in many ways control narratives, and then the ICC is also involved. So I'm slightly wary of saying that it's a nice, clean, isolated consideration of what's going on the ground that is then determined in a strictly legal way by the judges. I mean, these are highly politicized, and narrative is a big issue. And international law is a culture itself.
I think I could go so far as to say, well, yes, of course, I agree. These are big and difficult cases. And that's why the ICC was established, in order to deal with these big and difficult cases, because actually the barriers to prosecuting these cases are so large that under other contexts and without a special forum to do it, it simply might not happen at all. And we have seen also the ad hoc tribunals prove that it is possible to do this, and prove that it is an appropriate exercise of the international community's resources and time and effort. And the ICC, I firmly believe, can do that as well. I take your point, of course, and this goes kind of back to where we started the discussion. It's valuable for us to have as much public discussion, as much engagement about these issues in fora like this, in the context of policy, in the context of academic engagement, because obviously the more we have consensus before we start anything, the better it is. But when it comes to a criminal trial, as a prosecutor, I have to stick to the line that the ICC is a criminal court like any other criminal court, and all the actors involved will follow the law, and that's the process that the law dictates. And yes, it is for sure bigger and more complicated than other courts, but that doesn't have to mean that it's not fair, and it doesn't have to mean that it's not ultimately a reasoned legal decision based on the evidence.
Thanks, Matt. I certainly don't want to make you feel like you're on the spot. I'm out there thinking, but in full disclosure, I also happen to have a master's in anthropology, so I'm slightly biased towards the lack of anthropologists at the court. I find that quite extraordinary, given what we deal with, and simple things like cross-examining through 3 layers of interpretation is almost, well, I'm not going to say what I think. I mean, it's extremely difficult, I can tell you. Yes, I mean, the other thing is at the very beginning I mentioned that I was slightly concerned about the preamble to the ICC, well, to the Rome Statute, conceiving of culture as static, and I wonder how the court going forward will sort of learn to deal with shifts in culture. I mean, we've seen the sort of degree of controversy that can surround the pulling down of a statue in peacetime in the West, and obviously issues like pulling down Saddam Hussein's statue by victorious incoming forces. I mean, it's so complicated, and I just wonder, as you say, there's a great deal of sensitivity that has to be applied. Any questions from the audience? And I think otherwise we are well over time, so we'll probably wrap up unless my panelists have any further concluding remarks. No, Umar?
If I can just add a bit to what you said about culture being a dynamic process. One of the current questions beyond the statues coming down is also the issue of objects of art that are currently held in European museums that were taken from former colonies. And oftentimes these too have a lot of cultural value, but also there are some human remains. And this is also a new debate about the dynamic of culture itself. And even though because of the temporal jurisdiction, the ICC may not be the space to litigate these kind of questions, it's important to pay attention to those two, I think.
Yeah, I completely agree. Well, unless anyone has anything to contribute from the audience, I will thank you all very much for attending, and thank you for bearing with us as we went catastrophically over time. And thank you to the tweeters as well. And yes, it's been a great pleasure, and look forward to seeing you at the next webinar. And thank you very much to the panelists for such thoughtful remarks.
Thank you, Kirsty, for moderating.
Thank you.
Thank you.